I think we're going to go ahead and get started. Welcome. I'm Brooke Lovelace with the Iowa Developmental Disabilities Council. Thank you for joining us today for this important topic about advanced directives. And I also want to thank our partners at Disability Rights Iowa for recommending that we host this event. Just a few housekeeping items. Everybody will be on mute. We will be taking questions after the presentation. You can use either the chat button or the Q&A button located at the bottom of the screen to pop in your questions. I will be helping our speaker with the questions after her presentation. We do also have closed captioning available. You can turn this on the button located on the bottom of your screen as well. And if you do have any technical issues, you can put those into the chat or question comments as well. Now on to our speaker. We are super excited to have Cynthia Miller with us from Disability Rights Iowa. Cynthia is an attorney and the legal director of Disability Rights Iowa, where she provides legal representation and advocacy to individuals with disabilities in the areas including Medicaid, special education, community integration, guardianship, accessibility, and employment law. She earned her BA in English with distinction from the University of Iowa and her GD from the Drake University Law School. Prior to joining Disability Rights Iowa, she was an associate in a private practice law firm in West Des Moines, Iowa. So thank you, Cindy, for being here today, and I'm going to turn it over to you.
Great, thank you. And my thanks to you and everyone there for helping me with this presentation and asking me to discuss this topic. Just a little bit of background about Disability Rights Iowa. We are a nonprofit advocacy center. We are not related or connected to any state or federal agency. However, we are federally funded. We are authorized under federal law to do several things on behalf of individuals with disabilities, and one is investigate abuse and neglect of Iowans with disabilities and mental health. That's usually where we would go into a facility and also collect records and review situations. We can also pursue administrative, legal, and other relief on their behalf. So if you have issues related to our areas of focus that you can find on our website, you are welcome to call us and have some legal advocacy on your behalf. We represent Iowans with all types of disabilities and all ages from birth to death, and we also do not charge for our services. Today's discussion is about advanced directives. We're going to talk about what are they, what types do we have in Iowa, who has to honor those advanced directives, and what's going to happen if someone does not have an advanced directive. So first, it's really important to discuss why would you want to even think about an advanced directive? And this is one of those planning ahead tools where you can map out your own future for your own health needs. Other planning tools that you might already be familiar with are wills or maybe executing a trust. And those documents are really important, but they discuss your things or your stuff, what's going to happen to those things after your death. An advanced directive is about you and your body and what's going to happen with your medical treatment at some future point. So what the question is what would you like your plan to be for healthcare treatments if you could not speak for yourself in the future? Another thing that's important is it's a way to make your wishes known, have more control over the decisions that are going to be made about you. If you have religious or maybe even cultural preferences, this will become really important also to put into this type of document. The other thing that's really important that we don't think about very often is having a document like this is going to help eliminate confusions in time of crisis. I know sometimes even when someone says, where would you like to go for lunch? If I don't have a plan, it might be, I don't know, where do you want to go? I don't know, where do you want to go? And then you make a rush decision that in hindsight, you're like, that's not really what I wanted. Well, the same thing happens in the heat of the moment with medical decisions. It might not be easy for a loved one or someone that you've designated to make decisions under all that pressure. So this is a way to kind of ease that pressure and just have that plan ready to go. And then add a pandemic on top of it. You know, we all like to think end of life events are going to happen when we are significantly older or elderly, or where we've lived a long life of 80, 90, or 100 years. But there are things that happen to us along our journey of life that we're not expecting. And this advanced directive is a good planning tool to kind of address those issues. I did put COVID-19 on there because we've seen and evidence has shown that there can be a very quick timeline with this virus from the time of contracting it, sometimes to hospitalization, and then sometimes individuals end up on ventilators and or death. And that timeline can move very, very quickly depending on the individual. Other things that can happen are accidents, car accidents, stroke, and other terminal conditions such as cancer. One of the things that made myself and my family execute an advanced directive almost 15, 20 years ago was a case revolving around a woman named Terry Schiavo. This was a 26-year-old woman who had cardiac arrest and ended up having some brain damage due to lack of oxygen for a long period of time. She spent 2 years after that cardiac arrest attempting some different therapies to try to see if her cognitive functioning would increase or come back. And her physicians ultimately stated that she was going to end up in a constant vegetative state. So her husband elected to remove her feeding tube because he felt that's what she would want. However, her parents objected and they filed litigation to stop the withdrawal of those life-saving procedures. And they ended up in litigation for 7 years before it was ultimately decided what could happen to Ms. Schiavo. At that time, that was the cause for me to say, I would like to declare what I would like done if I was ever in a Terry Schiavo situation and executed my own advanced directive. So what are advanced directives? What am I talking about? It's a document. It's something that enables a person to make decisions now about what's going to happen in the future. It's an opportunity to get your preferences and your own decisions into a document. So I'm going to, in the next slide, I'm going to talk about the different types, but one of the type of advanced directives is where you can talk about, do you want a respirator? Do you want a ventilator? If you were put on a feeding tube or have some hydration provided to you, would you like that to be withdrawn? Do you want CPR, which is cardiopulmonary resuscitation? A DNR is do not resuscitate. A DNI is do not intubate. These are decisions that you can make. It also, an advanced directive is going to allow you to choose an individual who can make a decision on your behalf when you are in the position of not being able to discuss what you need or provide that information. So these documents are only going to take effect if the individual cannot express themselves directly. So if you end up in a car accident and you wake up and the physicians are discussing with you what your treatment options are and what do you want to do, if you're cognitive and you're awake and you have competency, then you can make those decisions and this document's not going to come into play. There are 2 types of advanced directives in Iowa law. The first is the living will. And this is the document that's going to tell the physician which life-sustaining procedures should be withheld or withdrawn if you have a terminal condition and you are unable to speak for yourself. The second is what's called a durable power of attorney for healthcare decisions. This is a document that is naming another person to make those healthcare decisions when you are unable to speak for yourself. So the named individual, it's sometimes called an attorney in fact or your agent, has to make decisions based on the directions given in the document. Now, if a power of attorney for healthcare decision is filled out, designates an individual, but then doesn't have any instructions specifically about what to do, then that individual or the agent will make decisions that are in the person's best interest. You can execute one of these documents and not the other. So you can have a living will, but not a power of attorney, or vice versa. You can have a power of attorney and not a living will. You can also execute both of them and you can execute both of them in one document. There's some forms that lawyers in different places have that have those two combined into one document. There are specifics about who can execute an advanced directive, and basically you have to be over the age of 18 and be a competent individual. There are also witness and notary requirements that will pertain to who can witness you signing the document and whether you need a notary signature. In Iowa, with regards to the durable healthcare power of attorney, there are two individuals who cannot be the healthcare agent. So one is a healthcare provider who's attending the individual on the date that the document is signed. So for example, an attending physician cannot be the designated person who then is going to be the power of attorney. Same for a nurse, staff in the nursing home or a hospital. The second is also an employee of that healthcare provider, but the caveat is if they are your sibling or some sort of relative, then that would be an exception. So our recommendation is you need to pick a trusted individual who understands who you are as a person and what your decisions will be. Understand what the responsibilities are for them so they can also make the decision of please don't designate me, or I'm not very good in a crisis. I don't really want to make that decision on your behalf, and talk to them about it. And pick someone who's really going to carry out your wishes. What do you do with an advanced directive once it's completed? Well, please do not put it in a folder at home and put it in a desk for no one to ever see again. Because the problem with that is hospitals, medical providers, your healthcare power of attorney cannot complete what your wishes are if no one ever sees the document. So it's advised to make copies of your advanced directives and provide them to multiple people or multiple agencies. First of all, the person that you've named as your healthcare agent, they must have a copy of it. Family members, your family doctor. If you're routinely going to the hospital for just routine care, take it with you to the hospital. I repeated myself with take to medical appointments, but nowadays with medical documents being electronic and online, it's not a bad idea to get that into your regular physician. They can then record that document into the online medical records, and then it'll pop up if you go to other places, usually within the system. And there may even be a way to access those documents cross systems. There may be other people you want to give it to, also pastors. You know, just think of who in your life really needs to make sure they know there's a document that exists and can bring it up in the event of an emergency where you may not be able to speak for yourself. Who is required to honor an advanced directive? In Iowa law, it states that hospitals, home health agencies, HCBS providers of waiver services, hospice programs, and then HMOs that participate in Medicaid all have to honor the advanced directive. Now, the key here is they have to know about it in order to honor it. So if something is done on your behalf that maybe goes against your wishes in the document, there are some provisions in the law that talk about liability without notice. So if they don't know about it, they certainly can't follow your wishes. So what about police or emergency services? For example, if you have a car accident, you have an advanced directive, it may not be possible for you to reach over to the glove compartment when the EMT arrives and say, I have an advanced directive, please don't perform CPR. You're not going to be in a condition to do that, most likely, if emergency services are called. So there's no guarantee in the event of an accident that your advanced directive is going to be honored. That's maybe one of the disadvantages of the document, but it's also emergent. There are some things you can do to try to get information into the hands of those emergency personnel. One would be to create some sort of card that you insert into your purse or wallet that advises them that you have an advanced directive that's been signed and how to get in contact with your agent. The other thing is the Iowa driver's license and the DOT has a provision in Iowa code that says you can add advanced directive information to your driver's license upon request. So if you look at your driver's license right now, there's down in the right hand lower corner, there's two boxes that will say organ donor, yes, no. There's also something that will say medical directives, yes, no. I looked at my own license last night and, you know, I was surprised that they were both checked. I don't remember doing that, but obviously I had at one point in time remembered to tell someone that I had an advanced directive that was executed. So a lot of times we all have good intentions to do something, but then we don't follow through. So it puts healthcare providers in a conundrum if someone does not have an advanced directive, they are currently unable to speak for themselves, and then they have to turn to someone else to make that decision. Well, what happened is states then enacted what we call surrogacy laws. So Iowa law is going to tell us what's going to happen if you don't have this document filled out. So I'm going to read the law, and then I'll come back to this slide and kind of break it down for us. But what it says for a living will is that life-sustaining procedures may be withheld or withdrawn from a patient who is in a terminal condition, who is comatose, incompetent, or otherwise physically or mentally incapable of communication, and that they have not made a declaration in accordance with an advanced directive that we've been talking about. If there is consultation and written agreement with the physician for withholding or withdrawal of life-sustaining procedures and any of the following individuals, and it has to be guided by the express or implied intent of the patient. So then when you look at the slide here, the designated individuals in their priority order is a person who has been designated as of a power of attorney. So this is one of those situations that perhaps a living will was not executed, but they did execute a durable power of attorney for healthcare. That person's going to be the first in line. The next would be a court-appointed guardian, then a spouse, an adult child, parents, and then followed by an adult brother or sister. So if you're an individual that perhaps knows that your decisions would be carried out by an adult brother or sister, but perhaps not your parents, then this would be a good idea to execute an advanced directive, because then you know that your wishes will be carried out by your sibling. I can think of a situation where parents are going to do anything they can to help their child, whether it's an adult child or not. And sometimes maybe those decisions they would make for you would not be in compliance with what you want done for yourself. So what's nice though about the surrogacy law is if you don't have the agreement, there's at least some way that healthcare decision makers can consult with family or the designated person and come to some agreement about what your withholding of life sustaining procedures are going to be. I would like to just state that who determines the terminal condition is a physician. So it's not a family member or someone else. It's going to be medical professionals that are going to decide that. Also, if an individual doesn't think that any of these individuals below, besides maybe the power of attorney, are capable of making that decision, then it's a good idea to think about executing an advanced directive. The last thing I'm going to say about these documents is they are revocable, which means you can execute one now and then change your mind later, or maybe change your mind about who you want to be the designated agent. So there is fluidity with the documents, but again, if you revoke an advanced directive, you've got to communicate that to the individuals that you passed out all of your documents to. A physician's going to uphold that document unless he knows that it's been revoked. The other thing is, if you have executed an advanced directive in another state, or if you're a veteran who has completed forms through the Veterans Agency, those documents can be upheld in Iowa as long as they meet the qualifications of our law. So as long as they were 18 and competent at the time of signing and substantially complies with Iowa law, those documents will move across state lines. I am going to pause here for some questions and see what has come up with the audience.
Sorry, I was on mute. It doesn't look like we have any questions right now. Maybe give a few more seconds just to see if some people are typing their questions in.
Okay. Well, maybe while we're waiting, I'll just talk a little bit about questions related to capacity and competency and who determines that. So sometimes you'll hear people interchange those two words, and they're actually really different. So competency is a legal term of art. It's when a judge or a court has made a decision that someone doesn't have competency to make decisions. We're probably most familiar with that comes through the guardianship law, where the definition of incompetency is that they need to have decision-making capacity that's so impaired the person is unable to care for his or her own personal safety, provide for their necessities, etc. On the financial side, it would be that their decision-making capacity is so impaired they cannot communicate or carry out financial decisions. Capacity is just the ability to understand the nature and effect of one person's acts. So capacity can sometimes be fluid. You may have capacity in one moment of time, but maybe not in another. You could think of someone who maybe has dementia and how they'll have a good day and a bad day. So, you know, you may hear someone say, I don't think that Cindy should execute an advanced directive. I just don't think she has the competency to do that. Well, unless there's actually a court order that says they are legally incompetent, then they have the right to execute that document.
I do have some questions now coming in. Can you please repeat the part about having a guardian named and the advanced directive?
Okay, so this is probably pertaining to this slide. If there is no advanced directive document, a court-appointed guardian would be the second in priority under Iowa law of who would have decision-making power. So the question probably is, if there is a durable power of attorney for healthcare executed, and then later a guardianship is established, who has the right to make that decision? It will always be the power of attorney because it was executed at the time the person was competent and had capacity to execute the document. And Iowa law says that they will uphold the power of attorney to have that right to make decisions. If there is no power of attorney and a court-appointed guardian is appointed, then the guardian is going to have the authority to make that decision prior to those other individuals.
Thanks, Cindy. The next one, do you complete these documents with an attorney or can you complete these on your own?
I would recommend that you speak with an attorney because then they can talk to you about the ins and outs of the law and what other things you need to be thinking about in terms of advanced planning. However, you can obtain these documents from other sources. And as long as you follow the Iowa law with the witness and the notary requirements, they're still valid. I've seen where hospitals sometimes will have these forms. You can go to the Iowa Bar Association and obtain the form. You can, I always want to say the Office of Substitute Decision Maker, which I know has now changed. I think it's Public Guardian here in Iowa, very likely has these documents. And you know, other Iowa Department of Aging type of agencies may also have access to the document. So you can fill out the forms on your own. I just want to make sure that you read very carefully how do you execute the document so that it's a valid document with witness signatures.
And you did talk about this, but just to repeat this again, Cindy, once court appointed as a legal guardian, do you need another court approval to make decisions?
Yes. When it comes to withholding or withdrawing life-sustaining measures, the Iowa Code under the guardianship statute does still require that guardian obtain court approval before making that decision.
one in the chat. I was wondering if there is any financial help for the person to have an advanced directive drawn up by a lawyer.
I don't know, but you could probably talk to a family attorney about, pro bono work, or between Disability Rights Iowa, Iowa Legal Aid, different organizations like ourselves that would do it free of charge. I would inquire around who's willing to talk to you about the document and what their cost is, and then try to find agencies that maybe are lower cost.
And Jennifer Donovan did have a comment from Department of Aging. Hi, Cindy. Office of Public Guardian does not have the forms. We encourage people to talk to an attorney if they really want to do it on their own. I believe ISBA has the forms available. And I'm not sure, Jennifer, the acronym ISBA is.
It's the Iowa State Bar Association.
Oh, okay, sure.
Yeah.
Good. Good. Another question, how detailed are advanced directives about specific kinds of care or situations? And are there guides or resources available to help facilitate the discussions between the person and the decision designee, either during the process of making the advanced directives or just to help the designee understand wishes?
Good question. A lot of the materials that I used to have are older, but when I reviewed the materials for this presentation, I didn't see that a lot of things had been updated, but this is my copy, but there was something called the Gift of Peace of Mind that was put out by Drake University, Methodist and Lutheran Iowa Health System, and the Iowa Department of Public Health. My last version is 2011, but this is a really nice document that it really is a step-by-step guide on how do you prepare an advanced directive document. It has, at the end, it has some really nice tables and boxes that go through different types of withholding or life-sustaining procedures, CPR, mechanical breathing, pain medications. So I would recommend, if this is still out there, it's on the web, is where I found it. Gift of Peace of Mind is a really good document. The Iowa Department of Aging used to have an older Iowa's handbook. Again, some of these documents may be a little more older in terms of publication date, but the information is still really well done. And then again, you might just want to consult with an attorney who can really go through the different steps of the document. I have the actual document here. It's tiny print, but there are spaces in the document that allow the individual to express their personal wishes. So if you just filled out the document where you say, I, Cindy Miller, hereby provide power of attorney to, whoever I choose, and I just sign it, but I never give any directions, that's okay, you can do that. But you also have that option to fill in those blank boxes that allow you to express very specific details and preferences.
How would you recommend getting an advanced directive for someone with a disability such as an intellectual or mental illness, assuming they don't have a guardian, and also assuming that they may not fully understand what an advanced directive is?
Having an intellectual disability or any sort of disability doesn't prohibit you from executing these documents. What probably needs to happen is to break down those legal terms of art into understandable language, so that they can understand it from wherever you need to meet them at. So for example, if someone has an intellectual disability, you may not say, do you want CPR? Maybe what you're gonna say is, in the event that your heart stops beating, would you like us to make it start beating again? You're gonna reframe the language in a way that's understandable to whatever the disability is for the individual. Again, be really careful not to make judgment calls about whether or not someone can understand something or execute a legal document. The law says if you're competent meaning a judge has not determined you to be incompetent under some standard, you can execute these documents.
And this is somewhat similar to that question, but what about individuals who were able to make their own decisions, but their mental health significantly declined and decisions they were making are threatening to their safety? Is someone able to become that person's POA, or does that individual need to consent to a POA?
With powers of attorney, you always have to have consent of the individual. So if someone does have mental health issues and maybe they're cyclical, so they have good days and bad days, this or even a power of attorney for healthcare decisions would be a really good document to have in times of when they are not, I'll say when they don't have capacity to make appropriate decisions. It also does come down to physicians, though, to determine who has that capacity and who doesn't. So again, it's another one of those judgment calls of, you may think they're not making good decisions, but people make bad decisions every day. It's when it's life-threatening or it has some really significant consequence that maybe these type of documents are going to attach to overriding an individual's decision-making.
And we do actually, Alicia did put in for us that link to the gift of peace of mind that you were talking about, Cindy, in the chat. So if you're looking for that document, it is currently in the chat for folks. Greg comments, I have my POA living well. I'm glad I watched today. Thank you for this presentation. It's good knowing I'm taken care of. One more question so far. Can a court revoke a power of attorney when the guardian is put into place?
That's a good question. I have not seen it happen because the law is very specific about a power of attorney having authority over a guardian when it's executed prior to the determination of incompetency. There may be, I can think of maybe situations where the power of attorney is not acting in the best interest of the individual, and that gets brought to the court's attention, and there maybe needs to be some decision making. I think that will be a very individual specific situation that's going to have to go before a court, but the law specifically says that powers of attorney that are executed prior to a guardianship being appointed, those POAs will survive.
And I did just, okay, that list, that gift of peace of mind now should have gone to all the panelists and attendees. Thank you, Connie, for pointing that out. And then Marcia asked about, she had to step away from her computer about getting financial help for an assistive directive if necessary to have a lawyer. And I think, Cindy, you offered your office as a help, and legal aid could possibly help with that too, I believe.
And there's some pro bono programs.
Yep.
Like Polk County has a pro bono program, and then other counties outside of Polk County flow through Iowa Legal Aid. So there's resources that you can try to get a low cost or no cost attorney to work with you.
That might. I think that's all the questions and comments we have for right now. Nothing else has come in. Any other final comments you'd like to make, Cynthia?
Just thank you for attending. Thank you for giving consideration to these documents. Like I said, with COVID and this pandemic, it's really brought a lot of attention to things that we've talked about all the time through our lives, but sometimes it kind of rises up the discussion of why we would need some planning documents like this. So just give it a thought. If you have additional questions after the presentation's over, you're welcome to contact me. I think our contact information is on the back slide here. I'm happy to answer more questions. And if individuals need to look at what the document looks like, again, you can contact me and talk more about it.
I do just have one other comment or question. If you are the legal guardian, can you petition for an addition to the power without using a lawyer, the power of attorney without using a lawyer, I assume is what that means.
I might need you to repeat that.
If you are a legal guardian, can you petition for the addition of powers of attorney without using a lawyer? Petition the court, maybe?
Maybe I'll ask that person to clarify. Are you asking if a guardian exists but no power of attorney exists? Can you execute a power of attorney after the fact?
Yes.
Okay.
She did add for guardianship powers.
Okay. I'll try to unpack that. So if there's a legal guardianship established, the individual cannot execute the healthcare power of attorney because the law says you have to be a competent individual. So when you have a guardian appointed, the court has made a legal determination that the individual is incompetent. So you can't do it after the fact. It has to be before the fact if it's going to stay. If what the individual is asking is that I'm a legal guardian, what decisions am I allowed to make with or without court approval? That will flow through the guardianship statute. I will tell you, for purpose of this presentation, withdrawing life-sustaining help is something that has to have court approval before it is done.
And we do have a question about the PowerPoint. We are recording this session, so if you did miss any of Cynthia's presentation or any of the questions, we will be sending out the recording of this. And Cindy, are you okay if we also send out the PowerPoint with that too?
That'd be fine.
And this will also be on the DD Council's website too. And one more question. What about financial power of attorney taking precedent over health power of attorney?
Well, healthcare powers of attorney only deal with the individual's body and their medical decision-making, and financial power of attorneys only deal with the person's finances. They don't cross, they don't mesh. So you can have a financial power of attorney, but they have no authority to make any sort of medical decision-making in terms of end-of-life decision-making.
But I think going back to that, more information about that one question you answered previous, Cindy, to add those extra powers, can you petition the court? Do you have to have a lawyer to do that if you want to add additional powers? Do you have to have a lawyer for that?
No, the answer would be no. You don't have to have a lawyer for anything. However, being a lawyer, I'm going to tell you that if you consult with an attorney, they can tell you what the statutes say, what the regulations say, and they can help you, guide you through the court process. If you do not have an attorney, then what you're likely to do is write a letter to the court, and the judge is probably going to set a hearing. They may or may not appoint guardian ad litem or some sort of individual to help you through the process. So again, as I said, I'm a lawyer, so I'm going to pitch, working with lawyers because we went to school to help you. Yes, you can do it, but whether you know what you're doing would be my concern.
Well, this has been such valuable information, Cindy. I can't thank you enough for doing this for us. Lots of good questions and discussion. And as we mentioned, we will send this information out to everybody that registered and put it on our website.
Great, thank you for having me.
All right, looks like that's it. All right, thanks everyone. Thanks for attending.